Yeah, you need to address the point of order. As a
I've
first point
addressed
of
all of
order
the
in
points
court
of order
the
that I'm
first
inclined
thing
to
you
address
must
today.
do is establish
Mr.
your
McLaughlin.
jurisdiction.
Validation of debt notices go out within the first 30 days of the initial demand. Defendant was way beyond that, period.
Welcome to Solving Citizen Legal Encounters. All right, as you saw in the snippet, we have two hearings today. One is out of Kansas, where the sovereign citizen just want to go in on the judge, but the judge shut him down. And the second hearing is a sovereign citizen who doesn't want to pay their debt. Okay, and before we go into the courtroom, I got to address four members, all right? It's going to be Steven, Andy, Chris, and Ramona. Thanks for joining the membership. Check out the community posts. Let's go.
Jesse Travis McLaughlin.
Yeah.
It's the state of Kansas versus Jesse Travis McLaughlin. It's case number 2024 CR 397. Mr. McLaughlin appears from a Hutchinson Correctional Facility Zoom location. Brett Sweeney appears for the state of Kansas. Mr. McLaughlin, I have before me a charge of battery against a law enforcement officer, a level 5 person felony. Since a felony is involved, we will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McLaughlin, that you, being in prison, don't have the financial resources to hire your own lawyer.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in
man
the
must
abundance
speak
of
for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point of
represent.
order. What gives you jurisdiction to appoint a lawyer over me?
I have statutory authority to do so. So, Mr.
So
McLaughlin,
what
I'm
gives
going to
you
appoint a lawyer at this
what
point.
gives you jurisdiction over me? You must establish jurisprudence as a point of order.
I'm not going to play your sovereign citizen gibberish game.
I'm not a sovereign citizen, sir.
Well, if you're not sovereign, what are you, huh?
All
I'm not
right.
a sovereign citizen.
You sound like one.
Well, I'm not.
All right. I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McLaughlin, noting he's made a request to represent himself. Again, that's to be a matter taken up fully before the assigned judge, Satterfield, at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or professional surety bond, though obviously it's not going to affect his current incarcerated status. All right, bond set, attorney appointed, court date established on Judge Satterfield's calendar. Anything else we need to address at this time, Mr. Sweeney?
No, Your Honor.
Mr. McLaughlin? Apparently not.
Yeah, you need to address the point of order. As a
I've
first
addressed
point of
all of
order
the
in
points
court
of order
the
that I'm
first
inclined
thing
to address
you must
today.
do is establish
Mr.
your
McLaughlin.
jurisdiction.
The McLaughlin matter is currently in recess, and we'll move on to another matter on the docket.
I object to moving on in any manner.
Objection noted and overruled, Mr. McLaughlin.
I guess he told you, huh?
All right, let's move
Request a
on.
copy of- I
Thank
request
you
a
to
copy
the
of the
Hutchinson
minutes,
Correctional Facility.
transcripts, these proceedings.
We can go ahead and take him off the meeting at this time.
Okay, that hearing didn't take long at all. Now, I noticed, and I'm sure you did, that little leash that he had taking him in the back. So maybe he has like some kind of mental issue, or maybe they just inmates there that really get rowdy. And I'm sure if he acts up while he's walking away and he snatched that thing back, oh yeah, his hand's gonna get pulled back. He gonna comply real quick. But anyway, let's go into the second hearing. Now, in this second hearing, you'll notice on the Zoom screen it says House of Jennifer. Okay, sovereign citizens like to use the family of, house of, that kind of thing. And that lets you know right away that's a sovereign citizen. Let's go.
This is case number 23-1659-92. This is LBNB Funding LLC versus Jennifer Moore. The matter is before the court, settling for a motion. Counsel, your appearance regarding this matter, please, sir.
Thank you, Judge. May it please court, I am attorney Richard Bruson, and my bond number is 35222, and I am the attorney for the plaintiff.
All right. It appears to me that there is a motion to set aside the default judgment that was entered in this matter. That motion was filed on January the 29th. All right. And do I have Jennifer Moore on the Zoom?
Yes. Good morning, Your Honor.
All right. Thank you, Ms. Moore. Good morning to you, ma'am. All right. And it appears that the plaintiff is moving. That's right there. Yeah. Well, no, I see the plaintiff's answer to the defendant's motion to set aside the default judgment. Ma'am, tell me why you believe that the default judgment should be set aside in this matter.
Well, to start off, I did call LVNV Funding when I checked my credit score, and that's how they were able to reach out to me. They were sending information to a different address, and according to Site 15 USCA 1692-, I asked for a debt validation. I asked for the payment of history. I asked for a signature of contract with me and the creditor. I also asked for if there was any insurance claim filed, as well as the title of chain of this contract. And I didn't receive any answer. Next thing I know, my mom was dealing with pancreatic cancer. I'm an essential worker. I have 2 disabled kids. So when they were sending out these motions and so on, I was unable to receive them because I wasn't getting any mail.
But when they open these accounts, everything is just fine. When it's time to pay back, they end up in court.
So on. So, and I reached out to the creditor, and they said that they gave my account to Midland. I have since resolved the issue with Midland, and it is paid. I then reached out to LV. They failed to give me all my information document needed. And now we're here. So I apologize for not appearing in court when I was going through my difficult times in life, but I am here now.
Okay, that's what you're telling me, eh?
All right. Thank you. Thank you, ma'am. Mr. Rusin, your response, I do see you filed a written response, sir.
I'm not sure how to respond to a lot of that stuff, Judge. I can tell you that I have been retained as the lawyer for LBNB Funding since November of 2023. I'm looking through my file right now, including electronic notes. I am all the way up to October of 2024. And of course, the register of action notes that judgment entered in this matter on June 12th of 2024, based on personal service of the summons and complaint. As I continue at the moment to keep scrolling down, I see that the first time defendant called my office, according to my staff, is December 5 of 2024, December 5 of 2024. And then, again, under 1692 of the act that she's citing, validation of debt notices go out within the first 30 days of the initial demand. Defendant was way beyond that period. Judgment was already taken against her. And so if the case continued, I can see that she filed an objection to the wage garnishment in this matter back in December of 24. And then the matter was argued on January 8th, Judge, on your record. She told you at that time, to my appearance attorney, that according to her argument, that, quote, the matter that's before Your Honor was with Midland Funding, which she paid. You indicated that she was attempting to attack the underlying judgment. The balance was given to defendant at that time of January 9th. So basically, as we've gone on now, Judge, by virtue of garnishment, There's there's about $89 I see statutorily owed on this case. I was frankly prepared to file a satisfaction of judgment. Oh, I see also, to perfect the record, that January 23rd,
I can't hear.
this case was argued. I'm not done, madam. The case was continued to press, and so uh,
Mr. Rosen,
here we
I-
are now with good.
Mr. Rosen,
I'm getting.
I'm stopping you because your device was breaking up. And that's what the defendant was saying, is that she's not able to hear you. It was going real smooth there until about that last minute, and something went miserably bad. And so you're going in and out. You indicated the last thing that was clearly heard was that you prepare to offer a satisfaction of judgment. You said only about $89 or so is owed.
Yeah,
But
exactly. Yeah, that's right.
after that, we weren't able to hear you very clearly.
Okay, so judge, there's less than $100 owed now, which was addressed back on the previous hearing in January. Just a second, I was there. You adjourned the hearing to the present date. Yes, January 24th, we were last on your record. Now the judgment is pretty well paid, and I am prepared at the moment. Well, I'm prepared now to file a satisfaction of judgment because it's all paid. I have no idea what Ben is otherwise arguing about, but on that I rest.
Well,
Let me ask-
for the rest of your honor.
Excuse me. Let me ask you, Mr. Rosen. Obviously, there's something about Midland here. Have you seen anything that shows a debt satisfaction regarding any claim, any indebtedness with Midland?
Yes, that's what you need to do today.
Yeah, but I'm saying, have you seen anything along those lines?
This case is never with Midland Funding. I don't represent Midland Funding.
Okay, well, but you understand my question, right? Have you seen anything from Midland as a part of your file or anything that shows that this debt is satisfied?
Well, I'm going to satisfy it now, but if she's saying that she paid this bill through Midland Funding, this case is never with Midland Funding. This is more or less a first assignment from Credit One Bank to LBNV Funding, and that's it. This is not a case that went passed around the room like last year's potato chips.
I know he didn't say potato chips.
It's a one-time assignment from Credit One Bank to Midland to LBNV Funding. Midland Funding is not involved in this, and I do not represent Midland Funding in my office. On that, I rest.
All right, thank you, Council Pam. I'm back
Your
to you
Honor,
this morning.
may I?
Yeah.
Thank you, Your Honor. And I agree with you. I also reached out to the original creditors. That's why we're here now, Mr. Rosen, because I did reach out
That's
to.
Rusin, ma'am. Rusin.
Oh, many apologies, Mr. Rusin, Attorney Rusin. I reached out to the original creditors, and they stated that my account was given to Midland, and that's where my account's set. Now, however, you guys transact the assignments on collectors end, that's not my specialty. That's not my profession. However, that debt was, and as of this day, my checks are not getting garnished, so it's paid in full. There is no remaining of $89 because it has already been taken out. And moving forward, for the record, Your Honor, if they can just, what I've been requesting and asking is a debt of validation. I'm asking for the payment history. I am asking for a signed copy of the signature with the contract of my signature. I'm asking if there was any insurance claim. These are my rights to ask. You guys, LVNV, should provide me this information. Now, the debt has been paid, but for the record, Your Honor, for my records, may I have this information?
All right. Thank you, ma'am. The central issue addressed by the motion in this matter is a motion to try to set aside a judgment that was entered by default in this matter. There would have to be a showing of good cause and a meritorious defense. And I've read the motion, I've listened to the arguments. I don't see a showing of any meritorious defense to the claim. Moreover, obviously, sickness would constitute some basis for showing a good cause, but you have to have both items, good cause and a meritorious defense. The whole notion of backtracking in this case prior to the entry of the judgment and demanding documentation of the debt and so on and so forth. None of that is relevant to the motion to set aside the default judgment. It's just the default judgment, you have to address the issue of whether or not there's a meritorious defense and affidavit to support that. And there simply isn't. And for that reason, after further reviewing this matter, for that reason, I don't see a basis for setting the judgment aside in this matter. It does appear that the defendant is entitled to a satisfaction in this matter, and that should be forthcoming from the plaintiff. If it's not, then the defendant may present to the court an application for satisfaction. I saw that there was something presented with the motion that was not in the form that is required post satisfaction of the judgment. That was a form addressing satisfaction of a judgment in relationship to Midland, and Midland is not the plaintiff before this court. So that's my determination. The motion is denied. Again, it seems that this is at the end of the road, and I look forward to receiving a satisfaction judgment to close this out. I do wish both sides well. Good day to you.
Well, Hustler Jennifer, I guess your little tactic didn't work, okay? Because you still have to pay the money. So I hope you enjoy watching both of the clips today, all right? And I hope you have a good day, even or night. And you know I'll be seeing you soon, okay? I'm out.